Okay. Thank you very much. As Florian said, I'm Jane Bailey. I'm a professor in the law faculty at U Ottawa. Thank you very much, Negla, for kicking us off. That was amazing, like a real sort of tour de force. As I'm coming to understand, you are a tour de force, in fact. I won't introduce you again. Just to say a bit about the other members of the panel. We have Bita Amani, who's an associate professor in the Faculty of Law at Queen's University and co-director of Feminist Legal Studies, Queen's. She's been a practicing lawyer, a policy consultant and editor, and legislative drafter with the Office of Legislative Counsel, and is called to the bar of Ontario. Welcome, Bita. And we have Emily Laidlaw, who's the Canada Research Chair in Cybersecurity Law and an Associate Professor in the Faculty of Law at the University of Calgary. She researches in the area of tech law and human rights, focusing on platform regulation, online harms, and corporate governance. Is also the author of Regulating Speech in Cyberspace, Gatekeepers, Human Rights, and Corporate Responsibility, and an upcoming collection on reimagining cybersecurity. And Andrew Selbst, who's an assistant professor of law at UCLA School of Law. His research focuses on the effects of machine learning and AI on varied legal regimes, including discrimination, policing, credit regulation, data protection, and tort law. Welcome, Andrew. Thank you for all of you for being up here with me. So the plan for our panel is that each person is going to take a minute or two just to give you sort of one key thing they want you to know about their work or their perspective in this panel on AI inclusion and equality on these particular topics. And then we're going to come back to have a few sort of questions and conversation. So, Negla, do you want to go, or should I?
I think I'll wait for colleagues. Yeah.
Okay, so I think a lot of my work in this field on algorithmic error and matching mistakes, and increasingly on AI and the technological reproduction and care, the reproduction of care, understandings of gender and care, is informed by my, I guess, positionality as co-director of Feminist Legal Studies. I was also a delegate to the UN Commission on the Status of Women for this past year for the Intercultural Network, WIN, Intercultural Women's Network. And so I think my key takeaway would be, as the expression goes from one of the works cited, my Equality by Design piece that's available online, Mismatches Make Misfits, and to pick up on Ian Kerr's work, since this whole event is tied to that. He's done an incredible piece with respect to the devils and the defaults, and I think that's where I think the conversation needs to go, whether we're talking normative defaults, technological defaults, legal defaults, and so forth. So I think that's what I would preface my help to it.
Thanks, Emily.
Thank you. So thanks for the introduction, because I think it sets up that, most of the work I've done has been in this area of tech regulation and human rights. And I think my particular obsession for the last 15 or 20 years has been this idea that a lot of the human rights we experience, whether you're talking about equality, free expression, privacy, when we're looking at tech, are increasingly experienced and regulated through private corporations. And so what does sort of a system of regulation look like there? And in a lot of the work I've been doing in online safety and online harms recently, a big focus has been that interplay with the role of AI, whether as part of the tool, as a solution, but also some of the extraordinary harms that flow from AI. One of the things I hope that we'll talk about in a little bit will be this growth of this of the idea of risk management approaches, both to AI generally, but also in the area of online safety when we're talking about due diligence models or duty of care. But what does it mean to frame it that way? What are the unintended consequences of that particular approach?
Yeah, thank you. Andrew.
Hi, yeah, thanks for having me. My research in this area sort of started 10 years ago, writing about discrimination and what we quaintly called big data, and then called data mining, and then called algorithms, and now call AI, sort of And it was really focused on, what I now come to see as the way AI sort of changes the fundamental understanding of how decisions get made, and how law seems based on this model of decision making that may now be kind of outmoded and needs to respond. And so I was focused originally on discrimination in a couple different arenas, employment, policing, some credit, and then how moved towards different models of legal regulation. So discrimination law is largely based in sort of ex post liability and the ability to say, hey, did you do enough in understanding this model and not making things worse for people, versus ex ante regulation that we've been talking about a lot. And so I've been sort of, and then the question of whether we create new laws or use existing laws, like all these sort of, dichotomous questions about how to respond to AI as a whole, with the harms that I'm focused on being discrimination, but it really could be any of the harms that, we've all talked about all day. So I'm really thinking about different modes of regulation these days.
Thank you. Nicola, did you want to add anything to what you've said?
Well, I just wanted to emphasize the work that we've done on gig workers, and I would like to get the opportunity maybe later during the discussion to show the nuanced narrative of gig workers at least in my region, but I find also similarities in the global south. So really, what does it mean in a context of the demographic context that I mentioned? What kind of opportunities and challenges, and how can we capitalize on this rather than demonize, the platforms, the Uber and the sister companies, and what this means for competition also. There is tension between the local startups and the multinationals. That's one area of work, and also looking at cloud workers, which is a different type of work that requires different skills. So cloud-mediated, platform-mediated cloud work. So looking at, like translators, architects, designers, etc. So these are two different groups of workers that each one has its own nuances. So that's, I think I think it's an interesting story that is also only found on the ground. That's what we find by working in the field. So I would be happy to talk about this later on. Thank you.
Thank you. And just to say a little bit about the Equality Project. So my work over the last, I don't know if I want to say, 20 some years, has been largely focusing on young people and their experiences in online environments. And sort of has resulted in sort of two obsessions of mine, which is this deep interconnection between privacy and equality, and a concomitant frustration with the constant efforts to treat these things as separate when we regulate. And then more recently, a real concern about things that have been mentioned already. I think Woody Hartzog in particular was talking about the sort of this continued reliance on the consent model when it's really failing, and it really has so little. It really isn't justifiable anymore, and I feel like we hide behind it in a lot of ways to make ourselves feel better about what we're doing, or what we're not willing to step in and intervene on. So that's a bit about me. So why don't we kick it off with a question? Andrew, I'm going to start with you. So we have a title, AI Inclusion and Equality, and maybe some people feel like terms like equality and inclusion are obvious, but I tend not to think of them that way. And so I wanted to get people's perspectives on in what those terms mean in this context, in their work and their thinking. So maybe you would lead us off on that.
Yeah, thanks. I actually really appreciate the question and the title of this panel, because I feel like what we talk about in the general, umbra of these ideas is usually bias and discrimination. And bias and discrimination, I feel like, have become these kind of hollowed out, very narrow concept where bias is, often discussed as this statistical mismatch within the algorithm that can be technically solved. Discrimination is often, at the moment of decision was something allocated in a way that, affects vulnerable groups differently, but, only sometimes. And it's a very it's narrowed, maybe artificially narrowed. Maybe we should have worked to expand the concept. But ideas like equality, to me, go a little farther, right? They're more substantive rather than purely procedural, as discrimination, at least in U.S. law, has really come to be. A leveling of the playing field, right? Like maybe it has power dynamics in mind, right? So much of what goes on with AI is really about, who's in power and who's taking more of that power and money for themselves. And so equality is about, not taking advantage of vulnerable people, but not taking advantage of people who are being made vulnerable as well. And then inclusion, to me, it can be tied in similarly. I mean, when I hear inclusion in AI, I hear, nothing about us without us, right? I hear about participation, but again, with the power dynamics, participation in AI is often, there's a temptation to make it so meaningless, right? Like when you look at the GDPR's requirement for consulting, or not requirement, even for suggestion that maybe somebody be consulted if there's if there's an automated decision made somewhere. There's nothing real. There's no meat there, and so there is this move towards participatory AI, and then there's danger that it will be window dressing. And so inclusion, I think, can be meaty, but it's also often there's a lot to think about there. So I really like it.
Yeah. Awesome. Does anyone else want to jump in?
Sorry, went on too long.
No, I don't think we
You do. For me, I think it's really important to focus on the idea of equality, substantive equality. I think in this day and age, most laws tend to be ostensibly facially neutral and formally equality is met. The concept of equity and EDIIA that informs that it came out of a period in which in international context you needed to overcome the limitations of formal equality, and so equity was considered to be a way to find some consensus around that to overcome those limitations. But the language of the law, and although we know rights are precarious and contingent, and Alan Sykes says they're also income elastic, and notwithstanding all of those limits on rights, the legal right is a right to equality, and that's in domestic instruments, it's in constitutional instruments, it's in international instruments. And so what that's been interpreted, whether it's under the Convention on Elimination of All Forms of Discrimination Against Women, or the elimination of all forms of racial discrimination or disability discrimination, substantive equality is the interpretive understanding, and that's really important, and not the language of equity only as a way of addressing that. The other thing on inclusion, I would just point out that I would say it's really nice, again, that we have inclusivity, but inclusivity doesn't ensure retention or participation. In fact, inclusion really should be about an understanding of inclusion as belonging. If the environment is hostile, you'll get attrition, no matter how many women you hire. If there's sexual harassment, if there's all sorts of implications. So inclusion itself also is a very limited concept with very limited efficacy unless you address the broader systemic social environmental issues in which we exist and relate to each other.
Yeah, good. Yeah.
I agree with my co-panelists 100%. And I like the term fairness, because sometimes you really need to walk the extra mile to make sure that you're fair to someone who's at a disadvantage. So in addition to all of this, I like the concept of fairness. And there is this cartoon where there is a ladder, and you give the equal ladder. But if you give a bigger ladder to the smaller person, then everybody will be able to see and participate. And so that's also, to me, is also, sort of sums up in addition to what my colleagues have said. So.
I mean, I love the answers so far, so I'll just make mine really brief, is that I want to kind of tease out that point of performative compliance. And I think that, I actually think that will almost be one of the big issues that we're scratching at for the rest of this panel is that issue of how do you actually make it meaningful. And if, especially if you're looking at corporate governance playing a particular role, it's always been that struggle with corporate governance, the idea that it actually just becomes a tool for marketing. And some of them are incredibly good at it, and it becomes a mask. And it's, even more problematic in the area of AI, what we don't have line of sight, to lift the lid, to be able to actually assess whether it really is just box ticking or not, or what they're not saying.
Yeah, this is just another little pet peeve of mine. So like as you can see by the color of my hair, I've been around a couple of blocks, and so I've always wondered about the transition from the term equality to equity, and been really troubled by the idea that there wasn't more attention and recognition being paid to the substantive conception of equality, which I think is important because that's the word that's in the law. And if we want to think, and some of us still do want to think, that the law can make a difference, I think we need to pour meaning into that. Yeah. So sorry, I'm like telling you all of my all the little hang-ups I have. But Negla, you gave us a real sort of panoply of ways of thinking about some of the ways that AI threatens equality and inclusion. And I wondered, I'm going to invite everybody, but I wondered if you wanted to sort of, were there sort of one or two that you wanted to sort of delve into a little deeper?
Well, it's just that I think of always thinking of how can we flip the argument? How can we use the technology for inclusion? Because there is just so much that can take place that can exacerbate inequalities between countries, within groups, by all dimensions, especially if you have multi-layered inequality to start with. So there is really a threat of, an existential threat, if I may say so. So in that sense, I think the efforts should go, and what we try to do, and try to look at opportunities where the technology can be used for inclusion, for mitigating the inequality, to be transformative. I think that's the word. How can we use transformative technologies? And one good example, I must say, it's in the area of agriculture, for example. There is an initiative that is in Egypt that is called Hudhud. It is an AI tool that helps farmers, with all the data on the weather and fertilizers and seeds and so on. This is an example, very simple example, but we turn things around in a way that empowers people who could use the technology. So I am at the lookout for those different layers of inequality in contexts where the issue of multifaceted inequality. I think that's what we're always looking for. How can we flip the argument around to find opportunities for inclusion and mitigating inequality?
Yeah, that's great. This reminds me of something that Ian was always reminding us of, which is, this sort of language of threat and opportunity, risk and benefit, and this sort of tendency toward, on the one hand, on the other hand, right? And that was part of his genius was trying to challenge that idea and to kind of move beyond that terminology, even though it's actually really hard, especially in if you're anyone who's ever looking for funding, because those words are words that funders love to hear. But Vida, I don't know, or anyone else want to say, if you were sort of to say, if someone says key threat from AI, is there something that jumps to top of mind for anyone?
Plausible deniability.
Sorry?
Plausible deniability. I think AI is so often sold in contexts where we're concerned about discrimination as a way of avoiding discrimination. And in fact, I bet there are still some people around who actually believe that. Most of them are probably in a position to employ someone else and use AI, whether they've convinced themselves or not, right? It's hard in that if people actually believe, this is the way to get the best job candidate, this is the way to get the best likeliness of having a loan repaid, and they actually believe it, and they're not sort of sophisticated enough in software, that the off-the-shelf software that they can really interrogate the off-the-shelf software they buy, then they're in this situation where they're trying to do, maybe even in good faith, trying to do the best, be the fairest, and end up discriminating potentially worse, right? A lot of people say AI could make discrimination less. It could make it worse. And we just don't actually know. There's often no ground truth because you're predicting the future, right? So there's no way to test. The notion of accuracy is actually made up, and it's an internally referenced, right? Where you hold out some of the test data. And so if the data set as a whole has a problem, you'll never see that in the notion of accuracy. So all these things where it could discriminate worse, it could discriminate better, and we don't know, but suddenly the employer is wholly innocent, right? In the sense that they tried their best. And so I feel like this rhetoric of neutrality, even though it's been debunked, still ends up with the point of decision-making and the liability associated with getting kicked down or upstream a little bit, or not at all, right? Either it's kicked upstream to the software developers, which is where I'd like to see it go a little bit more, or it just goes away. And that's, in my mind, one of the greatest threats of AI from a discrimination standpoint is it makes liability for discrimination go poof. We got to fix that.
And I mean, I'd add just on top of that, I think it's tied with something that isn't new, but worth emphasizing again, which is that this just belief that that the tech, that the output of the AI is correct, that it's reliable, that the story it tells is true. And even if we know better, I mean, we're quite a learned room. We see the headlines out there, but I think that most people, it's really hard in the face of some, statement that someone is at risk of recidivism to then say, oh no, they're not, and take that risk. It's like you're already fighting a decision that's been made. I keep thinking of it. So in disinformation research, they always talk about the idea of belief echoes, that people, even if the information's been corrected and they know it not to be true, the belief is still there echoing inside them. And that to me is sort of that echo effect of AI that we're fighting against. And I'll say that my other pet peeve, if we could make this a panel of pet peeves, is those discussions. I mean, I have the discussions with tech companies, and they're like, well, we don't have access to that data to be able to question what they're saying. And so when they'll say, but we can't do that, but we can't, dig through the data in this particular way or build it this particular way, and that there is really that information asymmetry between us and tech, and it's starting to level up a bit. And we're seeing, steps like through the Digital Services Act to try to open that up, but we're just sort of experimenting right now to try to correct that.
Yeah.
So if I could just jump in there, and I get the benefit of saying all of that, but also all of that came this morning and last night as well. I think the part of the concerns is, we know, and we've seen, and thank you for the keynote around this topic, that inequality is pervasive, it's systemic, it's structural. But what this does is it takes what is already ubiquitous inequality in the analog world, which many of us are resisting and championing against the inequalities. And then what it does, it scales it up en masse, and it automates the inequalities. And of course, there's a book on automating inequalities as well. And it does that in a way that then obscures or replaces law as technology with code, and the less it's work, code is code is law effectively. And you then have reverse burdens, you have flipped burdens, you have evidential burdens, so you can't prove what you don't know. You have all sorts of access to justice issues. So even overcoming the existing inequalities that are there become that much more difficult to police, and enforcing your legal rights of equality become harder to actually make justiciable. And so there's all these kinds of implications. And of course, then there's actually implications, of course, with both. And again, this has come up in the literature I've cited in my AI and equality by design piece, but you have overrepresentation and underrepresentation. So with as you were saying, with the tools for predicting recidivism, you have the implications of, is there predictive parity? Does the tool work equally well in terms of its accuracy, but also in terms of false positives and false negatives across populations? And then you have other things that are specific to not to those types of problems with the tool or the training data, as we've heard earlier in the conversation today, but the tech itself. So green light technology, which is tied to Fitbits, is used in, I think, some 350 clinical trials, but has difficulty in terms of its predictive parity in monitoring the heart rate of people with darker skin. And so this is not about improving your clinical trial set of who's represented in that, included in that data set. It's actually the technology is flawed, but given such priority. Similarly, we have predictive parity problems with object detection, that's a euphemism if I've ever heard it, in autonomous vehicles, which have difficulty predicting objects, people of darker skin. These are existential questions then of life and death that show that the problems of inclusion and exclusion are not just about equality, they actually have real serious implications.
Yeah, absolutely. And all, like, I felt like running through a lot of that was it's that veneer of mathematical and scientific certainty. I think that often leads people to feel intimidated and sort of undereducated and often results in people being excluded from conversations, even though they're bearing the brunt of the outcomes. They're not often not included in the conversation about regulation or design or anything else. Okay. Now, one of the things Negla kind of touched on this, but I'm gonna start with Emily on this question of how our understandings of the harms of AI are influenced by engaging with, learning about, knowing about the experiences of individuals and groups that have been harmed, and how that influences our perceptions of AI's harms and threats.
Yes, and I'll answer this just to make it really concrete in the area of kind of online harms and online safety. And I think that you see AI really used in kind of two ways. One is just the business model itself, right? You know, it's the recommender systems, whether it's algorithmically amplifying, demoting content, it's the advertising system that's pushing data that way. And it's also AI is used in just content moderation itself and trying to resolve and address complaints or deal with online harms issues. And, you know, I think we've all seen in really good and bad ways. Some of the harms, there's so many, but I'll just note a couple things that really stuck out to me when I was thinking about this. One is the collective harms issue. And this was discussed a bit earlier when it came to privacy, this idea of group privacy. But thinking of it in terms of, say, you know, just mind hacking and the real vulnerability to freedom of thought, right? We see it with disinformation campaigns. I think that there's an extraordinary risk when it comes to virtual reality and interference and manipulation of our minds. But we're seeing it at a more basic level when you look at amplification of eating disorder content, self-harm. I mean, during COVID, there was this just rash of tic disorders among youth because of videos that were circulating on TikTok. Racialized and marginalized groups are the most targeted in online spaces, but I think one of the issues is that the solutions to the problems also end up being weaponized against users. So, you know, you see, you know, marginalized groups bearing sort of the burden of this system of freedom of expression. And then the solutions themselves are being turned against them as well, whether it's, you know, complaints mechanisms being weaponized to target particular individuals. We need to listen to groups with their specific vulnerabilities and about what solutions they want. I think that, you know, Jane, you have done so much work through the Equality Project on this. And you know, when you talk to youth, when you talk to, you know, women in vulnerable situations, when you talk to other vulnerable groups, you know, let's take intimate image abuse. What do you actually want as a solution? Let's talk about hate speech. You know, when you talk to racialized groups, you know, okay, we might, you know, I always hear the answer, well, you have crime on the books. And they're like, well, you know what? I don't actually feel that great going to the police and making a complaint about that. I don't feel heard. And also, practically speaking, it doesn't tend to offer the solution that they're looking for. And so sitting down and talking to those groups. I would say that the other is just, this is my kind of big comment, is we have, I think we're in the big issue with AI too is a climate of polarization. And it's because a lot of work I'm doing is that free expression, equality, privacy mix, right? And it's hard to get anywhere in a conversation because expression And, these values under the Canadian, for those of you who aren't Canadian, equality, expression, privacy are all of equal value under the Charter, right? But it's hard to get anywhere with the conversation because it's seen as any discussion about maybe limits on expression or somehow just this existential threat. Or similarly, you could have the same conversation without privacy, but we need to get into the nuance and talk about the hard parts, talk about the ticks and children, talk about the impacts in particular groups. Where I see it play out concretely, and I'll stop here because I know I've consumed a bit of time, is discussions about lawful but awful. That it's a non-starter in conversations because it's like, but I have the right to freedom of expression, lawful but awful, how dare you go there? We saw that in the UK, and basically they were cutting at their online safety bill. And I keep thinking, well, surely we have to have a conversation here about what the harms are. And if we see rights as deeply meaningful, then we need to talk about how these rights are mutually reinforcing and what that design, that regulatory framework will look like. But we can never get there because it seems to be a non-starter in conversations. Yeah. My rant's over now. I'll stop.
Anyone else?
Just say that Bill C-27 and the ADA and artificial intelligence data, it conceives of harm, broadly speaking, both as economic, physical, mental, property-based harms. If the sort of the obligations to, prevent bias and harms, again, so much is left to the regulations, so we don't really know in terms of substantive application where we're going to go with this. I think it shows, though, I think there are limits, of course, to equality even as a legal right. So first we have to get beyond equity to equality. Then when we look at the equality even as a constitutional right in the Canadian Charter, for example, Sonia Lawrence has done really great work around this issue with Section 15 jurisprudence, really looking at courts don't really want to talk about the Section 15 rights because then you have to deal with the reasonable limits discussion in Section 1, right? And so oftentimes decisions are made on other constitutional grounds were raised, and or the jurisprudence sometimes reflects, the paucity of evidential record, which is then used to rationalize the decisions around Section 15. And I think that's the kind of the true concept of the real threats here is that even where it's not lawful even. So there's limits to the lawful, so we have that. But even when it's not lawful, there are limits to even advancing those interests within existing paradigms as they are. So looking for the disparate harms and disparate impacts within that, when our entire system is based on individualized conceptions of the atomistic self, liberal self's rights, and those concepts rather than the broader relational concepts.
I'll say harms inform a lot of the work, especially I think, in the U.S., right? We have such obsession with any litigation, right? Like we have standing doctrine that has very flexible notions of harm, and like any sort of intangible harm, just kicks people right out of court. But I think that goes more than just literally standing doctrine, right? Like throughout law in the U.S., how we conceive of the harm, how concrete a harm is. So we had the last panel when we talked about medical devices. So when you talk about discrimination in medical devices, you got a physical harm there. Somebody suddenly cares about it. Something like employment, we've established, okay, that's a discrimination harm you can, that's cognizable. Something more like maybe your facial recognition in your iPhone works less well for certain people, and you can make that a consumer harm if you've paid for a certain amount, but it's starting to get a little bit less concrete. And then we talk about privacy harms, and so what we're able to regulate and like the approach that we're able to take to regulate it really, I think, depends in a large part on how concrete the harms are perceived to be. And part of this is we also had an earlier discussion about individual versus sort of society-wide harms, and society-wide harms are often not considered harms. They're just politics, right? And so thinking about the harms, I think it's often in the background of these discussions, or at least for some of us. I mean, I'm sure it's not for most people, for a lot of people, but with the legal discussions, it ends up in the background a lot of the time, but informing everything that way.
Yeah. Michael, did you?
No, I hope that
Yeah, I think there's been like such a nice through line for me in this sort of discussion about the impacts of liberalism and the sort of atomistic liberal individual and how that's it's really limiting our imagination and our capacity to address something that is really presenting collective societal issues. And when we're trained to focus on not only individual harms, but then we respond with individual remedies. We don't have, it feels like in Western, North American, sort of Western traditions, it limits our imagination and our capacity, I think. Bita, we kind of touched earlier on this idea of, you know, could AI, it's like almost like the AI for good kind of argument, right? Like the ways in which AI can actually be used to facilitate or to contribute to equality, inclusion, and accountability. And I think we have heard some examples from other panels, but I wondered if you wanted to comment on that.
Yeah, I mean, I like to be positive and try to keep it positive, notwithstanding all the stuff going on around. And I think, you know, there's a couple of things I would reference. So, for example, Iris Bonet in her work, What Works, and referencing equality by design, mostly in the analog world, really, but still looking at, again, data feminism effectively and what can be done with identifying areas where those inequalities are, the gaps in equality and how they are. And certainly we see, for example, Carissa Mathen's project here, looking at jurisprudence, is equality jurisprudence, is looking to use sort of data analytics to assess that jurisprudence. And we can see why in some jurisdictions like France, they want to ban the analytics on judges' decisions accordingly, because maybe we don't want to face some truth in terms of the truth groundings. But so there's those, and then there's companies that are working in this space too. So Mila has Biasly, which does natural language processing to look to see where there may be gendered language used. There's private firms, Fairly, for example, is engaged in using these tools for good and for positive. It's been used by the UN. So I have a book that's co-edited with Caroline Nakubi and Matthew Rimmer coming out on intellectual property rights and sustainable development goals forthcoming, hopefully by the end of this year. And my chapter was on SDG 10, which is the reduction of inequality between and among nations. And in that context, I reference some data on the UN's use of data analytics based on the voluntary national reviews that were submitted. And I think they reviewed something like 100 out of 158 of these voluntary national reviews. And to find, though, on the analytics, so this is for the 2016 to I think 2018 period. In any case, but to find the ranking of the country's preferences and priorities of the SDGs, SDG 17, the partnerships being ranked highly, and SDG 10 being ranked last in terms of priorities. So notwithstanding the fact that the UN Secretary General has said whether the 2030 agenda will be achieved and the SDGs will be achieved is really going to come down to primarily equality, right? And eradication of inequality. And so the data analytics can really help identify the areas that greater work, mobilization, agency, activism, resistance is all necessary, and where we together need to mobilize to affect change, to make sure that both within and across nations that SDG 10 is met and inequality is reduced.
Mm-hmm. Sure. Yeah, I would like to say a few words about AI in work, because typically what happens with technological revolutions is that usually it ends up being people will go out of work and the demand will be for the higher skilled workers. This took place in the 90s when the IT expanded, especially in the US, and with statistics that shows that income distribution has worsened. So what happens, they're saying whatever work would be replaced by machine can be replaced by a machine will. So what does that mean is that people are expected to be out of work in the medium medium skill level. And the clear example which takes place is people in call centers, so it's usually replaced by a machine. So it's very important to see what's happening as, the policies that are taking place there. The flip side of this is that these technologies also offer work, like I mentioned, the gig work, which is platform-mediated work on the ground, Uber and sister companies, which is usually the working conditions are precarious. They're put at a disadvantage compared, of course, to regular work. But the irony and the nuance is in the Global South, my country as an example, but also we see similar conclusions for our partners, with our partners in South Africa, is that this work, the alternative is really very grim. I showed you statistics on unemployment of youth and the educated. So what happens is that we flip the argument, we work through the Fair Work Project with the companies, with the private sector, with the actual platforms on how to improve the working conditions of the workers. There is a methodology with the Fair Work Network developed by Oxford Internet Institute, and we have the network in different countries. And what happens, it's a scoring exercise. So we interview the workers, we interview the platforms, and we go to the platform workers with a provisional scoring. And we tell them this is going to be published, so they are incentivized for their own reputation. They work with us and not everyone, to improve the conditions of the workers. This ends up being a win-win situation, and we involve policymakers at the same time and civil society. Why do I say this? Because it is a way to sort of flip the argument and present these platforms as, examples actually for other types of work. I know it sounds strange that these would be the good guys, but the reality is, in contexts where the alternative is unemployment or informal work, this is sort of another animal altogether, and it can work for the benefit of the people if steered well and if the platforms respond. So then, for example, we had acceptance to put a data protection policy for workers, to give them better representation. Now, the irony is, who responds? The local startups. International Uber doesn't. They are very nice. Actually, the manager was my student. We have a cordial relationship, but they never really respond in taking anything further. So this gives you another angle, is that there is a competition story here, because you would want to encourage local entrepreneurs, the startups, who actually work with us to improve the conditions of the workers, and it's a process year after year. So there is, you see the difference between the local startups and the multinationals and the large companies who are not responsive. We found a very similar trend with our partners in South Africa. The better performing platforms are the ones that are local, homegrown startups, young entrepreneurs who work with us from the beginning as we start our process, and we have our workshop to explain. So it is, work is really an issue, and I think it's in contexts where it is challenging as the one I'm living in. It's really important to try and do our best to mitigate the challenges that are offered for work. And if there is an opportunity to improve work opportunities, by all means, we do them. Just one other word about cloud work. Again, cloud work is also, as I mentioned, the sort of a higher skill work that is offered to young people. Again, it's not ideal. It has its precarity. And it's more difficult to work on because it's harder to find. You found the ground workers because we know the workers, we see them around you. Cloud work is more challenging, but the project that we have in the region, we're working with partners to interview, different workers in the two different fields and try to see what are their needs on the one hand, and on the other hand, trying to see because they are invisible in the data landscape. So we work also with the National Statistical Offices in trying to see them, to put the lens on them and help them, rather than just demonize them or, immediately go by taxing them. We try to see them and see what their needs are. We mitigate the two groups, get them together and try to work forward with evidence-based research. The one other work I'd like to cite is that's upcoming with Open African Innovation Research Network. We are the North African hub of that. We did the scoping study on regulation for innovation, which I think is the approach that is commended, because we look at regulation, again, not just of AI, but of the different surrounding legislative package, because the example I mentioned about the gig work, it's really a competition issue. We want to encourage young local entrepreneurs rather than them being put at a disadvantage against the large players. So this is sort of in addition to what I mentioned about feminist AI and governing responsible data and AI in MENA is what we're working on right now.
Yeah, lifting up the local, for sure. Did either of you want to say anything about that? I was going to, somebody that I think some of my graduate students in my graduate class are here, but anyone who's ever been victimized in my graduate classes knows that I talk a lot about Langdon Winter. And the whale and the reactor. And so years ago, he argued that, we were all technological somnambulists, that we were just sort of sleepwalking through technological change, and that would ultimately change our ways of life, change us individually, and sort of never have any input on what should be developed, and if so, how. And I wondered, before we turn it over for question and answer, Andrew, if you could start us off. What do you think of that, now as a description of what's happening with AI?
So I think it in some sense, in the sense that we're all around and being acted upon and like passively unable to do much, may be accurate, but I think the passivity of it is a little too forgiving to the people who are imposing AI on the rest of us, right? It's not that we're all sleepwalking, it's that, we've created a system of government that has at least again, I speak from the US, but has a non-interventionist stance on tech, sort of based in this idea that all innovation is good, that, people with money are, not quite literal gods, but, that, this sort of, this basic idea is all there, that has let people create AI and not really obviously describe the benefits of it, and then throw it all out in the world and dare us to do anything about it. And so far, not a whole lot's been done about it. And so I just don't know that I like this sort of passive view on it, such as we've structured society and refused to, we talk about things like the pacing problem, right? The pacing problem isn't a problem, it's a stance, right? It's a view that government should get the hell out of the way of technology instead of actually proactively regulating, or even using the laws we have, right? We have some of my recent work, or earlier today, we talked about the Federal Trade Commission. I think Woody mentioned it. The Federal Trade Commission starting to actually act on AI stuff, and that's they have authority to regulate unfair and deceptive practices, and they're finally moving, but their law's been on the books all the time. What about all the AI that just doesn't work, right? Forget discrimination, it's just broken, right? And it's being put on the world and harming people. Yeah, they can go after it, right? So for a long time in this space, we've been talking about needing new laws, and there are all these laws out there that we also weren't enforcing. And so I guess within the sort of non-interventionist on tech, hyper-capitalist world that we're living in, you could describe it as sleepwalking, but it's not accurate, I think.
Emily, that kind of ties some themes between, the role of the impact and the role of the people and regulatory structures. I wondered if you wanted to sort of end us off on this part.
Yeah. I'd love to, thanks. So, just thinking in terms of some of the possibility of Canada, I'll just say, is going through this tremendous law reform right now in this area. There was discussion about Bill C-27 and new privacy and I don't know if you can call it an AI Act. It certainly doesn't seem like the federal government is taking AI seriously if you read what has been proposed. And in the area of online safety, we're still waiting for a bill. But to give you an idea, we have no comprehensive law in this area in Canada, while Europe, of course, is on their second iteration already. But the idea of the models out there are this idea of risk management and due diligence. And I think that there's some really interesting equality issues that are worth paying attention to, because when you're talking about risk management, how does that actually square with issues of rights, right? Free expression, equality, what is left in the dust? Because it does seem like a cost-benefit equation. So often, I mean, when you're looking at, you create a regulator, the regulator, assesses systemic risks of harm of organizations, it's proactive, fantastic, I have advocated for it. But you're also looking at things in the aggregate. So things get smoothed out in the process, right? So in particular, looking at issues of inequality that are at the edges might get pushed out of the way. So what happens to those individuals? What happens to groups in this process? Is there a liability framework that's attached to this? Because that idea of the individual having some avenue to some sort of remedy. And how do you quantify harms here? Because the assumption with risk management is that a certain amount of harm is okay. And we have to wrap our minds around that, right? The idea that there's an error rate. That might be appropriate for some things, like if you're looking at content moderation and the commitment to freedom of expression, you want to usually err on the side of freedom of expression and maybe have other systems built in to deal with it. But different when you're talking about risk management of different types of AI, right? So I will leave it with, risk management is not foreign to human rights. I think if, anyone who's worked in the area of the business and human rights and the whole guiding principles, that is essentially a risk management framework for businesses, the idea of, these duties and ongoing mitigation of risk and right to a remedy, yada, yada, yada. But I think if you're looking at any then legislation that might be proposed, or if we're looking at any risk management in this area, that it needs to be rights driven is critical, because otherwise if they're not doing it through human rights in that lens, then they can easily just ignore it and it becomes a discussion of cost benefits. So,
Yeah, exactly. So we should open it up for questions now. Questions, comments, happy to take those. Yeah, Marcelo.
So much. I enjoyed this panel so much, the discussions. And I think there is a common theme which Jane identified, moving from perspective which is concerned only with individuality, with issues that are more common. And I think this doesn't entail a denial of individuality, right? I think this is something that the things are not opposed to each other. We can celebrate our individuality, but also our ability to get together when things are in our common interest, right? And moving from consent, right, to an understanding of privacy that is more normative and more social, ideas of societal harm, right, that have been discussed as well. One of the issues that I would like to know from you is this. There is the discussion, right, of the small ledger, right? The person who is smaller will need a bigger ledger. Right? And we have this assumption that mechanisms of social scoring or social evaluation shouldn't be part, for instance, of the AI Act. Right? And I wonder whether we can have inclusion without evaluation of our differences. How can we tender someone a bigger ladder if we're not able to embed in the framework something that accounts for that? I wonder whether the scoring is itself the problem, because the scoring seems to point to an outcome. And the machine doesn't need the score. We need the score to know where we stand. But the machine doesn't need the score to operate at all. I would rather have a score to know where I stand than not to have a score. So my question is, from a perspective of social inclusion, what do you see the role of systems of measuring of some kind that can account for our differences? Do you think there is a positive role to be played by AI in this regard? or this is something that shouldn't be part of our thinking at all?
Yeah, thanks. I mean, I think I also almost said this in response to the "can AI be used for good" idea, and it's like technologies. I'm not going to say they're neutral. They're not neutral, but they can be used in good and bad ways, right? It's all about the context and the surrounding uses. And so in some sense, the scoring is a problem in that it encourages us to, take account of things that are easily measured and ignore the sort of intangibles. But it's also because of how it's used, right? If it's used to rank and allocate as a result, the very same system could be used to figure out where people have some deficiency that would, or like, something that causes them to get a low score that you could then provide to that person to aid them, in equality, right? So it's literally the same system that's making the same prediction that either says, this employment candidate gets the job, or this person gets some extra materials that allow them to, get the next job, right? Literally the same system, but nobody's going to do that second one. And so it can theoretically be helpful, but I think it requires being in a system, a society that prioritizes doing that. And to that I say, okay. Good luck. I'm too cynical to think that we're getting there.
So
Peter wants in and then.
I always try to be somewhat more hopeful. Of course, different states have different obligations under the law. So the United States is not a signatory to the Convention on Elimination of All Forms of Discrimination Against Women. They're not a signatory to the International Covenant of Economic, Social, and Cultural Rights. So when I was at the UN and I was at the Commission meetings in March, it was really interesting to see how on the CEDAW, I went to a few CEDAW panels and sessions, and on the CEDAW implementation, there was mobilization at the municipal level to effectively generate CEDAW compliance in order to bypass the state's failure in that context to implement those obligations for gender equality. In Canada, we also have a Gender Budgeting Act that requires accountability for budget allocations for gender. The last panel talked about gender-based analyses, and that's a requirement for CEDAW obligations to conduct gender-based analyses with respect to the laws and therefore the implications. And then you see parallel provisions within the other contexts of the other agreements for race, disability. Disability needs a lot more work because within the equality discourse and literature, it's the often least examined area, so a lot more, including invisible disabilities like mental health issues, needs a lot of work. And then I think we shouldn't forget the role so we go from technological discrimination and pattern recognition and social sorting, classification, and conversations that we had last night. But the fact is, Section 15.2 of the Charter requires special programs. CEDAW requires special programs. That is, we are required to implement special programs that would address systemic historical harms, which means that there should be actually coding for discrimination that corrects by way of special programs. Now, implementation will be difficult, but we saw with the GDPR, the concept that was generated by a Canadian privacy commissioner, and Kalukian, of privacy by design, was adopted as a legal default in that context. We have yet to adopt it as a legal default per se. And if we adopt that in tandem with an equality by design principle, I think, then we can effectively then leave it just as privacy by design was to industry to say, okay, now you come in and help us figure this out by establishing standards, implementations, how to do audits, equality impact assessments, and then bring industry on board. And suddenly now you have a market interest in doing the right thing, I would say.
Yeah, if you think that you're pessimistic, you have no idea. Yeah, I go back to Winter's observations that there are certain technologies that are just inherently political, and that they drive towards certain things. And so even though they can be used for one thing or another, like I'm always hyper conscious that when you get dropped into certain kinds of socio-economic, cultural settings, like it's it's highly probable that they'll drive towards outcomes that might be just reinforcing the bad places we've already gone. But that's just me. Like, that's not ending on a high note. So let's have another question.
Perfect. Thanks for such a thought-provoking panel. While you were speaking, I was thinking about a hypothetical in my mind. We're talking a lot about advocating for these subgroup analyses to be done, gender, sex assessments. And I was thinking about if I was, in a hospital leadership position, having to make a procurement decision on an AI technology. And for biological sex males, the technology reduces mortality by 80%, but for females, only 20%. I'm thinking about that discrepancy, and should this be a tool that gets adopted? Should the hospital have a framework around when to draw a line of what gets adopted or not, knowing that there is an 80% mortality reduction for males? And then the second part would be, would transparency alone to the public or to patients be enough to sort of counteract some of the issues? And I'm not saying it is or it isn't, but I'm just curious your thoughts. So transparency as in, hey everybody, just so you know, we're gonna adopt this tool. It's gonna work 80% good here, 20% bad there. I'm curious your thoughts, because as we do these analyses, which are gonna be great for doing these gender analysis, subgroup assessments, we're gonna see these variations. So how do we grapple with what's going to be coming as a result of those analyses? Thank you so much.
Anybody want to take a shot at that? Yeah.
So I laughed when you said that, because I literally wrote about that medical example in a paper about negligence and AI and talking about medical malpractice, and pointing out that actually the discrimination in like medical negligence that involves use of some sort of technology is new, because there was never a technology where the outcome depended on who you were potentially injuring, right, before this. And so it poses this weird situation where we really have to ask whether if there's like full improvement for the dominant class, whether we care about the discrimination aspect more or just the overall health outcomes more. And I resolved it there by not resolving it. So I mean, my answer to that is I have no idea. And I think this is like one of the many conversations. I mean, I think one of the things that in discrimination we kick the can a lot on discrimination without doing hard issues as a matter of sort of legal theory. We've never really defined what like is enough of an injury for disparate impact. We don't really have a great idea of it, and we sort of muddle along. And I think what all these statistical measurement, like when we concretize it in AI, there are so many conversations that were uncomfortable, and before we kicked the can because it was like human error and whatever, like, okay, so we either hold someone liable or not, it's common law, yada, yada, yada. And like, this is one of the many conversations. Like, if we have health is one of the very few areas where kind of everybody agrees on what the goal of AI should be, unlike something like employment, where there are plenty of people that might say, hey, we actually want the better candidates, whereas health, it's like everyone wants better health outcomes. So that's like the perfect example that it's really, really hard to figure out if you have a better health outcome overall that happens to be discriminatory, what you even do. I don't know.
I think I'm going to tie this back to that earlier question regarding LinkedIn winner's point. I think there are lots of people who are active in speaking in this space, including Timnit Jabru and the DARE, the Distributed AI Research Institute. We have Redlet Abebi, we have Ruth Benjamin, we have Virginia Eubanks, Sophia Noble, Kathy O'Neill. There's lots of people and working in the space, and they're not necessarily being heard, but they're working in the space, and sometimes they're being maligned specifically. And so, for example, Tim Jabru had talked about, some of the inherent problems of binary classifications of male-female, for example, in even that example, we might say. But I think that, in part of the gender-based analyses, and I've done some work in the context of sort of toxicity and chemical pollutions, you need to look at, for example, differences like different body burdens between men and women, and the storage, therefore, or implications of toxicity from chemical exposures, everyday chemical exposures, and then regulating in terms of, what are allowable or not. And so I think, I'll just diverge for a moment from that point, just to say the gender-based analyses are still really important in some ways, or really specific to the demographics of the populations and the implications of regulating in a particular way or not. Within Indigenous communities, we see this as well with respect to those who live around the Sarnia location with higher miscarriages and so forth, stillbirths in proximity, so geolocation, body burdens, all of these things should be considered in terms of the disparate harms of a particular application. That's using a different example, but we can carry those types of thinking across, and we're required to by law to do that as well. I have to say, I do agree with your earlier point about some technology should just be banned, and I would agree with you, Woody, about biometrics. I would agree is one of those because it's so amenable to state of use in particular, but also its problematics of not fit for purpose and accuracy and things of the sort.
Sorry, if I could just jump back real quick. Like, you made me think of another important point in that, like, the basis of the question might not turn out to be necessarily right, because just like all these gender analyses, like there's a lot that's unknown. The actual algorithms themselves, right? Recent research has shown that they're incredibly sensitive to initial conditions, and so often, like, you'll have prediction algorithms in every field with a set error rate that's not like 0, that's not 1%, but it's like 15. And as a result, you can actually get the same accuracy with different distributions of harm or of error rates and things like that. And so even having something where we know it's, beneficial for some group or not, if you train it differently, there are ways to make it potentially to rebalance while having the same kind of accuracy and error rates. And so there are other things that we could try to avoid these kinds of situations. And I think this is new computer science research. And so what else is there? So, like, there could be more answers on the technology side. That's me being hopeful.
I really appreciate the question because I've been thinking about the use of technologies in justice systems. And one of the conclusions that Jackie Burkell and I have come to, and a lot of the work that we've been doing, is that if nothing else, we're going to force to the surface some hard choices that actually we've been making all along and have been hidden below the surface, and that we'll have to confront them directly, and we'll have to talk about them, and we'll have to understand what's our principled reason for making this really hard choice. And then people may agree or disagree, but to actually be able to put it out there and confront it in a direct way, instead of sweeping it under the carpet, which is so often what gets done. Which is not an answer, but I think that's a really important question, and it's really helpful in the health context, especially because it's got such a, people have such a gut reaction to what the stakes are. Yeah, great, thank you for that. Yeah.
Hi, I'm hoping my question kind of brings us full circle to where we started when we were talking about calling this inclusion and equality rather than free from bias and discrimination, because I agree. I think the challenge is that the conversation is so much around representative bias and distribution inequalities, but in fact, we still, even so, I still find even in these kinds of conversations, we're so focused on harm avoidance and risk of causing harm rather than ensuring that if we're going to take something as complex and challenging as AI to solve a problem which we have defined, then we should be able to demonstrate at the ideation phase that there is a problem that needs to be solved, and ask ourselves right at that stage, are we being inclusive and equal in defining that problem statement? So to illustrate with the platform workers, if the problem statement had been, people like me, I like flexibility. I'm on the good side of the gig economy because I'm a freelancer and I get to but I have bargaining power. But if I'm living hand to mouth, I'm not going to have the kind of freedom and flexibility of being a gig worker because I'm always waiting for the next call. And if I say no to it, the algorithm's going to downgrade me, it's going to impact my profile and so on and so forth. So when we were designing the problem statement, who were we thinking about? We were thinking about CEOs getting fatter bonuses. But if we want to think about improving, by cutting overhead costs and those overhead costs are employee benefits, job security, stability. That's a cost to society that basically was downloaded onto us to make profit margins higher for certain corporations. But if the problem statement had been, we want to make it less costly to have products, you could probably replace the CEO and maybe automate that or something. Like, that's where the big cost center is, right? The CEO salaries, as opposed to what it costs for the, paying benefits to workers. And then we wouldn't have to be paying it ourselves with welfare or social issues that flow from it. So my question after that big long statement is it at the stage, should we be spending more time, or as we're thinking about how, the policy solutions, should we be demanding more of entities or companies who want to propose an AI solution to demonstrate a demonstrable benefit to society, rather than just only demonstrate they've managed the risk of harm?
Can I just say one thing about that? I think that I would want to start with them showing us that there's actually a problem, rather than this is a solution looking for a problem. I find the cart often comes before the horse here, and that often generates these sort of reverberating effects. But open up the panel, yeah.
Yeah, and so this is me entirely coming at this from my particular lens, right? Where I'm like, what's the legal solution? Can we do something in regulation here? So, there's lots of ways to approach this outside that, but I think that one of the real struggles here, because I think we can say, okay, in principle, absolutely, we need to start from the point where, from the design phase of even like conceptualizing this, it needs to be done, with kind of a whole picture, right? Do we need to do this? What are the particular impacts? Does this actually solve a problem? The question is, then you say, okay, should this be legally mandated, right? And this is where you see GDPR has done sort of a privacy by design approach. But then you say, well, how do you actually implement that, right? And I think we still have the issue of this idea of corporations, how much is left to just sort of corporate governance. And I think we start from the basis that at this stage, there should not be faith that companies will just, rise to the level and deliver whatever it is they're going to do. And in the good, that I would view this as a space that needs to be regulated. But trying to make meaningful that at the design level, what needs to be known and how you implement that and what is seen as enough is incredibly complicated, I think, from a regulatory perspective of what kind of oversight is needed, what is bespoke to each company, what do they actually need to do, because the risk is that checklist that we've talked about. They're like, of course I thought about equality, and I thought this was a really good idea, and there's definitely a problem, and then it gets fixed that way. So I don't fully have a solution here. I'm actually I think that this is what I hope to see with regulators as we develop over time. And I think that the big pressure right now is on transparency reporting by companies. But it's difficult to make transparency reporting meaningful. I always think of just, in the content moderation space, thinking of, what was it? I think it might have been Facebook was like, well, we take down 99% of content, terrorist content. And it's like, yeah, okay, but within what period of time? It's actually over like a 6-month period, which is pretty useless, right? And they don't report that particular data. So making transparency meaningful as a combination, as an aspect of accountability here, I think that's the money question. And I invite everybody in this room to go figure out how we can make that one concrete, because I think that's what the regulatory experiments are.
But I think my question was really about, at the point of saying, so for example, earlier today, we were talking about licensing regimes, right?
Yeah.
So there are all kinds of people who want to get patents, but they don't get patents for just anything, because there are criteria, right, for what qualifies for a patent. Or if you want to put a drug out on the market, there are criteria, and there needs to be something, right, that you do. And I know it's not.
Oh no, 100%. And it might be like licensing. You are starting to have there are proposals about licensing as the approach to some AI systems, and that's why I think we see these like high risk AI systems maybe have particular regulation, and that is criticized too. And they're like, well, what is high risk, right?
That's the harm focus, right? So
Yeah.
I feel like the problem with the harm thing is you have such a great due diligence defense, especially with.
I don't see them as, I see them as both, right?
Yeah.
So my view is that you have to have both, that you are doing a harm analysis, you're also doing a rights analysis. You're looking at how do we deliver on equality? How do we deliver on privacy? And how do we do that in a way that is balanced also against the risks of harm? Because it's sort of an ecosystem of proportionality. And so when I talk about that, I'm not just talking about one, it's sort of delivering on both, but we'll see what happens. Because I will say that in regulations, they tend to then say, and we'll do this respecting fundamental rights. And I don't know, I do not think that most of us know what that entirely means. So
Nigla would like to.
I'm just going to make a side comment. I really like what you said, and how I'm thinking now at this point, of time in the day is that maybe we're looking at, business models that have been there forever and just trying to, make the best of what is there. But perhaps with the technology, maybe something else is going to come up altogether. Maybe new business models are going to come that may give the opportunity for fairer workspaces and new creative ideas. It's reminding me of the IP, discourse a long time ago when we were making a case of new business models, with copyright and so maybe there is new business models are going to come, maybe new opportunities for making a fairer workplace will emanate, and I would like to think of this as a positive note, rather than fighting, a fight on models that are already existing and trying to fit new work models that are not ideal in this scenario. So that's my last comment. Thank you.
Last word.
I think a fair, ethical, responsible AI, accountable AI, all of that is really critical and important. But at the end of the day, it has to be legal AI. So to your question and to your point, if it's not compliant with the laws, and this is not only just an integrative law and policy approach, or what I would call cross-policy coherence with the law, if you can't ensure that it will be legally compliant, putting aside the need for improving laws to make them more substantively equal as a separate issue, then it should not go to market. If you cannot ensure that it's legal, it should not go to the market. If it's not a human right, and the human rights protects against constructive discrimination, for example, you are required to discriminate under 15.2 with special programs and stuff like that. So that's all fine. But if you are not capable of being compliant with the law, which includes constructive discrimination under human rights legislation, then you're not ready to go to the market. Full stop.
Okay. Well, thank you to the panelists. Thank you all for your questions and your attention. And I think we're now moving on to student paper presentations and maybe I see some wine at the back. So that seems promising. Thank you very much.